We're generally a pretty mobile society. So, what happens if you create an estate plan in one state and move to another? Does it really matter where you create your will? Generally speaking, as long as the will is validly executed, that it is a legitimate will and not just words on paper, it should be able to be probated in any state where you move to. So, if you started in one state and moved to another, it doesn't just become magically invalid just because you relocated across state lines. It's that it may be more difficult to probate it in the new state, and it won't specifically contemplate any legal nuances or rules that may be distinct in the new state that did not exist in the old. And so often, if we are moving for good and not just for a short period of time, it's appropriate to consider updating just to have local versions of the documents that you already have. It will substantially reduce any administrative procedural hurdles that may exist by having to prove an out-of-state will is actually valid, but it'll also be more easily recognizable by local authorities and even things like powers of attorney at banks and hospitals. We don't run into as much resistance with North Carolina-based documents as we would with out-of-state documents. But of course, that's where legal and practical sometimes are not in alignment.